NACDL is the association of the nation's criminal defense bar.
Thanks for the introduction. It's great to be here. So our game plan is I'm going to cover some of the technical background on how and why the government hacks in criminal investigations. Riana is then going to talk about some of the legal complexities associated with hacking as an investigative practice, and Colin's going to talk about litigating these matters. So I'm going to start with a little bit of technical detail, but not too much technical detail. As we heard earlier, computer scientists are nice people. Okay, so let me start with the motivation for what the government's doing in these cases. So the recurring fact pattern that's led to government hacking is the government's in a position to associate particular criminal activity with a device or an account, right? So someone who's signed up for a website is doing something unlawful, or someone using a particular a computer or smartphone or tablet is doing something unlawful, but the government doesn't actually know the person sitting behind the screen or the person behind the account. And so it needs to find a way of determining that person's identity. There's another fact pattern that hasn't come up so much, but I want to mention it, which is where the government knows who owns the device, but physically accessing that device isn't possible or is too risky. And so the government might use a hacking technique to get data off that device instead of a more traditional seizure and then search of the device. Okay, so now into the technical details. So when you access a website, your computer talks directly to a server. So I picked my, I currently work at Princeton, so here's the Princeton website, and I thought it was very fitting that for all the public interest lawyers in the audience, the top line article from Princeton is about debt. At any rate, so let's suppose you're accessing the Princeton website. Here's what's going on behind the scenes. So let's say that laptop on the left is your device, your laptop, and on the right we've got Princeton's web server. Your device goes and talks to Princeton's web server, and Princeton's web server sends back, here's the Princeton homepage, and some information about how to pull up the images and the fonts and all the other stuff in the web page, right? So that's ordinarily how accessing content on the web works. Let me be a little more precise about the steps in between the user's device and the web server. So the traffic will generally, this is a little bit of a simplification, but generally go from the user's device to an access internet service provider. So that might be Comcast providing cable service at someone's home, or it might be Verizon Wireless providing LTE service on their cell phone. It's someone who provides access to the end user. That data will then go to some backbone ISP that carries the data across the country. The data will then go to a so-called transit internet service provider that provides service to the company, in the organization, in this case Princeton, and then finally the data will get to the server that it's directed at. And the return traffic will kind of go in the opposite direction along a similar path. Right, so that's the steps in between the user and the web server. And why I wanted to go into this detail is it matters for investigative purposes. So ordinarily, when the government wants to investigate a user who's committing an online crime, they start by observing that every device associated with that online activity has a unique address called an Internet Protocol address or IP address. These are just made up examples. They look like this. And the government will say, okay, we have seen a user with 1.2.3.4 committing an online crime. Using free online resources, the government is able to identify the access ISP, right? So this is a Comcast user. This is a Verizon Wireless user. The government then goes to that access ISP, usually with a subpoena, saying, tell us who had this IP address at this time. And then the ISP keeps those records and is usually in a position to tell the government, here's who the person was. then the government has identified the person, can go do a traditional search and seizure, or all the other traditional investigative techniques. So that's usually how identifying an unknown person committing an online crime works. Okay, so what's caused the government to have investigative difficulty increasingly is a fairly popular technology called Tor, stands for the Onion Router. Tor has tons and tons of legitimate uses. It's actually funded in large measure by the US government. For example, it helps folks speak about issues with unpopular perspectives in countries that aren't as speech-friendly as ours. But Tor is also used to commit online crimes, and the very point of Tor is to mask the end user's identity. So let me go into a little bit of detail about how that works. So the fundamental insight of Tor is that if you got an end user's device with its IP address communicating directly with a web server and its IP address, that very connection is sufficient to identify the user's device, right? If you have the IP address, you can go to the Access ISP, you can get the user's identity. And so Tor makes it possible for a user to mask their IP address, and it does that in a very clever way. So first off, it adds a set of intermediary servers between the user's device and the web server. And the user's traffic will pass through those intermediary servers before reaching the web server. By default, there are 3 of these intermediaries, and they're called Tor routers. In addition to adding these intermediaries, Tor uses encryption in a clever way to limit what each of these intermediaries knows about the traffic it's handling. Bless you. Let me explain, again, not in too much technical detail, how that works. Okay, so the idea here is that each of the intermediaries has a cryptographic key, a little bit of information it can use to identify itself and enable the user's device to know it's talking to that server and only that server. And so the user will build out an encrypted communications channel like this. First, it'll set up a communications channel to the first server, where it knows it's talking to the first server, and the data is encrypted for just the first server. Then inside that channel, it'll set up a connection to the second server. And it nests that inside the connection to the first server. And so the net result is the first server knows it's talking to the user's device, it knows it's talking to the second server, but it can't see the data flowing between the user's device and the second server. To be precise, it can't see the content of the data. And then the same process plays out with the third server, right, nesting this encryption again, and then finally it goes to the web server. And so the end result of this process, the user's device is certain that first, these servers aren't tampering with the data that is moving through the network, and second, any particular server only knows what's in front of it in the network path and what's after it in the network path. It doesn't know the entire network path. And so the net result is no one's in a position to respond to that hypothetical subpoena saying, here's who the user is. So that's how Tor works. As I said, not too much technical detail. Okay, so here's the response the government has been using to folks using Tor in the course of criminal investigations. And I'm going to represent the government software here with the Ladybug. Back when I first started giving this talk, as is common in computer security, I used a creepy crawly bug to signify the government software. Folks from DOJ didn't like that, so I'm going to use the Ladybug. Okay, so the Ladybug is the government software. The government gets the end user to load the government software onto their computer, usually via deceptive means. I'm going to get into that in a little more detail shortly. So gets the end user to load the government software. That software will then initiate a network connection directly to a server controlled by the government or a contractor working for the government. And that direct network connection will bypass the Tor path and will include the user's ordinary IP address, giving the government the traditional information it uses to investigate the crime. right? So the idea is they're not actually breaking Tor itself, they're circumventing Tor to get the user's IP address. So that's the technology that's used for committing these crimes, and the technology the government uses to respond to that and investigate the crimes. Okay, so I want to encourage you to think about a few key steps if you're dealing with one of these network investigative technique cases. The first step is, how did the government get the software onto the suspect's computer? And so one way in which that could happen is so-called phishing, right? So the government will send an email to the suspect, get them to click a link or open an attachment. Another way in which the government might get the software onto the suspect's computer is a so-called watering hole attack, where they'll put their software on a website that the suspect goes to, and then it'll load into their computer. The Playpen case, which has received a lot of attention, and which Riana and Colin are going to talk about, is an example of a watering hole attack. So there's the delivery phase, which may or may not trigger constitutional considerations. Then there's the exploitation phase, where the software that the government delivers will circumvent security protections in place on the individual's computer and make that direct connection back out to the government. And so, for example, in a case out of the District of Nebraska, the government took advantage of a flaw in how the Adobe Flash plugin handled network connections and used that to work around Tor. In another investigation, the government took advantage of a bug in how Mozilla's Firefox web browser handled its memory and used that to bypass security protections and make a network connection outside of Tor. So the details here differ and are worth getting into, because again, that can have constitutional implications. And then the next phase is actually collecting up and reporting back data from the user's device. And depending on what data gets collected on the device, that too can have constitutional implications, right? So, so it could be an IP address, could also be configuration information, it could be files, could be turning on a webcam, and depending on what information is at issue, there are various Fourth Amendment doctrines that could come up. And then last, there's sending data back to the government, usually just via that direct connection to the government server. But again, you could imagine, depending on how it's done, there could be constitutional implications. So those are the pieces of the technology puzzle I want to encourage you to think about. Those pieces are going to be fairly constant from case to case, but what actually the government does under each of those pieces is going to differ and might matter to your litigation. Okay, so let me close by teeing up some of the challenging legal questions associated with government hacking to identify Tor users. The first is, are these searches regulated by the Fourth Amendment? The next one, how do you establish probable cause and particularity if you're not searching a physical space, but rather an electronic space, and one the government, at least in the first instance, knows nothing about, right? Doesn't know where it's physically located, doesn't know who owns it, doesn't necessarily know what information is contained in it. How do you notify folks who have one of these searches executed on their device? Changing their wallpaper probably isn't a good idea, but there are a variety of options you could pursue. And another recurring issue, what's the right venue, right? If you don't know where you're going to conduct the search, there's been a change in the federal rules that my co-panelists are going to talk about that's clarified that some, but at least for a long time was a tricky issue. So a number of issues that get teed up by these technical details. Let me close with two shameless plugs. The first being, if you want to know way more information about any of the technical stuff I covered and some of the constitutional implications, there's an article in the Yale Law Journal that you might be interested in. And with respect to contacting computer scientists who might be able to help evaluate these matters, as the prior panel mentioned, we can sometimes be helpful. Feel free to shoot me an email, even if I'm not in a position to help out. I'm happy to try to point you in the direction of computer scientists who might be able to help out. As the prior panel said, we're nice folks. Let me close there, hand off to Riana, who's going to talk about some of the legal challenges that come up in this space.
Gonna sit here and be the lazy person. I'm wearing high heels and we don't want to stand up for like 20 minutes in a row. So, all right. So I'm going to go over the law, as Jonathan said. Thank you for that great technical introduction. So I'm going to run through some of the aspects of most of the case law in the context of government hacking has been made in the so-called Playpen cases that Jonathan adverted to. So I'm going to run through the Fourth Amendment law and then also discuss the rule change to the federal rule of criminal procedure authorizing warrants, which is Rule 41. If you are in state court litigating over a warrant that was issued by a state court judge, the rule change may not be that relevant to you, but the Fourth Amendment challenges that you can raise are still going to apply, and you'll hear a bit more from Colin about the specifics of how you might want to do that. And these government hacking strategies might not be as common yet by state investigators, state and local authorities, but they're going to be coming. They're already partnering with the FBI for a number of techniques, which themselves tend to have trickled down from a military and intelligence context. So it may still just be on the horizon, and in the federal context, we're already seeing this pretty frequently. So the first question is whether or not the deployment of a NIT on your client's computer constitutes a search within the meaning of the Fourth Amendment. The majority view is yes, it does. That seems, pretty uncontroversial, right? And this is typically decided under the CAT's reasonable expectation of privacy test, where you're looking both for whether there's a reasonable expectation of privacy in the place to be searched, that's going to be the device, the computer, the laptop, and whether there's a reasonable expectation of privacy in the information to be seized, which is typically going to be identifying information such as an IP address. And you have a reasonable expectation of privacy in your computer, in your cell phone. That's the majority view in these cases. And the courts have used two rationales. We heard yesterday a bit about the Riley case governing the need for warrants to search a cell phone, and how the court said that there's this digital is different type of theory that came out of that. So the courts in government hacking cases have applied that same rationale. The Riley court referred to cell phones as mini computers, and so a fortiori, for regular size computers, obviously, there should be a reasonable expectation of privacy on this digital is different rationale. And then in addition, there have been a series of appeals court decisions, federal appeals courts, that say that we have a reasonable expectation of privacy in the contents of our home computer because, well, it's in the home, and the Fourth Amendment protects the home. That also extends to other areas such as hotel rooms, such as offices. So, if you're just surfing child porn at work like you do, then, you have expectation of privacy in your office as well. The home analogy sort of raises the possibility that in addition to trying to argue to a court that this is a search and you have reasonable expectation of privacy under the CATS framework, you could also revert to the older trespass-based, property-based theory of Fourth Amendment protection, where the court in the 2012 Jones case said that physically occupying private property for the purpose of obtaining information is a search. And the rationale here is the NIT deployment is a physical invasion of a private computer. The government is sending code to the computer's memory and causing it to send information back to the government. So you could try that as a theory. Whether or not that would stick, I'm not sure if that's been extensively tested. And the Jones case also said that in solely electronic surveillance situations, the CATS analysis should be applied, but that doesn't necessarily mean that you can't still throw that at the wall as well, like we do. So, in addition to looking at what's the place to be searched, that's the device, you also want to look at the information to be seized. And here, the law is not so great when it comes to IP address in specific. A lot of courts have said at the Court of Appeals level that there is no reasonable expectation of privacy in an IP address. They largely base that off of the third-party doctrine, where if you are disclosing information to a third party while browsing the internet, such as your IP address, well, you don't have a reasonable expectation of privacy in your IP address. And the lower courts in government hacking cases have extended this even to IPs that were hidden by using Tor, even though you're trying to maintain your privacy by using Tor to keep your IP address hidden. The courts have said, well, but in that first hop, as Jonathan was explaining, you still have to disclose your true IP address to somebody, to some third-party Tor node. And so most courts have gone along with that, but at least one court in the Arterbury case has said, look, this isn't the usual third-party doctrine context where you're going to the defendant's ISP and asking them for information. Here, you had to deploy malware that had to reach into the defendant's computer in order to get that to phone home. That's not the same as the usual way of mediating information via a third party. But it's important to remember that NITs can seize other information besides the IP address as a means of helping to identify a target computer. And the courts have said that there may be a reasonable expectation of privacy in that other information. So if you have one of these cases, take a very careful look at the warrant to see what information does it say, what types of information is the NIT supposed to collect, because if it's in addition to IP address, you're going to be able to argue that there's a reasonable expectation of privacy in every category of information there. And so even if IP address might not be a winner, you should be able to hopefully find reop in something like a MAC address. There is a minority view where some courts in government hacking cases have said that a NIT deployment on your client's computer is not a search within the meaning of the Fourth Amendment. And this is mostly an illustration of the way that most government hacking cases so far have arisen in the child pornography context, which is just radioactive. We've seen so much bad law being made, where the courts have been really willing to bend over backwards into contortions in order to ignore like settled Fourth Amendment principles in order to keep a CP case alive. And we've even seen one particularly bad offender in this regard is this Madish case from the EDVA in 2016, where the court said, well, hackers can illegally break into your computer, and so you don't have any reasonable expectation of privacy in anything on your computer because it might get hacked. And it's like, wait, so somebody can illegally break into my computer and that means the cops don't need a warrant to like go plant malware? Well, it's like saying that you don't have any reasonable expectation of privacy in your home because everybody knows that robbers can crowbar open your door or throw a rock through your window. It's ridiculous. So luckily, even though this was published in FSUP 3rd, that case seems to have largely been consigned to the dust heap of history as it deserves. So moving along, in addition to trying to establish that there's reop in the place to be searched and the things to be seized, you also need the warrant to be supported by probable cause. And unfortunately, again, this is maybe a particularity of the CP context in which most of these cases have arisen. Courts have typically found probable cause. So to take a step back quickly, Jonathan mentioned the Playpen cases. You may be familiar with these. Playpen was a notorious dark web site, mostly serving child pornography, that went up in 2014. At the beginning of 2015, the government took it over, moved the server that was hosting the site to a site within the Eastern District of Virginia, kept the site up and running for 2 weeks to use a watering hole attack after getting a warrant from a magistrate judge in the Eastern District of Virginia that authorized the FBI to drop a NIT on the browser of every single person who visited the site. As soon as they logged in, the malware was dropped on their browser. And so over the 2 weeks that the government was operating a child porn site, thousands of computers worldwide got infected as a result of this one single warrant issued by one single judge. And so that predictably yielded dozens and dozens of cases around the country that were litigating over the validity of this one single warrant, which occurred before the rule change that I'm going to discuss shortly. And we've already seen, just in the last couple of years since all of these cases started springing up, there have already been, last year and this year, about half a dozen Court of Appeals decisions as well that have weighed in on these cases. So just a massive amount of litigation across the country on the basis of this Playpen site. But pretty uniformly, when defense challenge the probable cause for dropping malware on somebody's browser just because they visited a website, the courts have typically said that there was probable cause because due to the steps required to get to this site, that it was on a Tor hidden service, you needed to have Tor to be able to use it, you had to have a login to get into the site to see it. It's not likely that you're just going to be browsing around on the internet and accidentally stumble across this stuff. And so there's PC, that the defendant knowingly viewed or possessed child pornography. Colin's going to talk about why there's a lot of disputed underlying facts to support that. That's also, again, there's a particularity of the fact that the Playpen site was almost, though not 100%, content that's illegal just to view, not merely to buy or to exchange, but even just looking at it is illegal. And so if you have a watering hole attack where your client supposedly visited a website that contains mixed legal and illegal content, the probable cause inference there is going to be weaker. To take another example, before the Playpen case, there was the freedom hosting case. Surprisingly enough, the Playpen case was not the first time that the government had seized a CP site and served up CP to many willing customers. Prior to that, the freedom hosting server was a server that the government seized, ran itself, dropped malware on everybody who visited it, but some of the sites that were on there contained CP and other sites did not. And that included a site called Tormail, which is a web-based secure email service that was used by journalists, used by dissidents to be able to communicate securely with each other. And yet everybody who visited this server got malware dropped on their browsers, even if they were completely innocent of they weren't visiting any parts of the site that were serving up CP, and some of them were people who had a really desperate need to be able to keep their communications secure. So there was no PC to drop that on their browsers, and so the poor targeting for the NIT in that case is something that I think the government has learned from since then. Now, as Jonathan mentioned, you're not always going to be looking at a watering hole attack. There might be other ways of transmitting a NIT to a client or a target computer that might be such as phishing, et cetera, and you're going to need a different basis for probable cause in those situations. An example of that might look like whether the email address that the government sent an infected attachment to was one from which threats had been made or attempts to defraud a potential victim had been made. So, where am I? So I'm like jumping ahead like once or twice here. All right, here we go. So after you challenge PC, you want to move on to challenging the particularity of these warrants. NIT warrants tend to authorize extremely broad searches. And so if you are looking at the particularity for a warrant, you can go for both specificity and overbreadth. Again, looking at the Playpen cases, this is just one warrant, and the Playpen NIT warrant did not identify any specific devices or their locations, contrary to the plain language of the Fourth Amendment. Most courts have said, well, the description in the supporting in the warrant says computers of all users who log into the site, that's the place to be searched, that's the thing to be seized. Most courts have said that's okay. One or two have said, look, how are you supposed to know, it's the reverse gin joint problem. You're going to search all the gin joints in all the world, and you're not specifying which gin joint you're going to walk into with your malware. But the level of specificity that is required for a hacking warrant, for any warrant really, is dependent upon the amount of information that the government has. If the government has more specific information than they are listing in the warrant, you can go after them for that to say, look, you had more information about browsing habits or time spent on the site or other factors that you should have included in the warrant application, that you should have included in the particularity requirements here. So you hold the government to the amount of information that they have if you can find that out. And of course, the problem with these government hacking warrants is that the location is the object of the search. That's what you're trying to find out. And you can't specify what the place to be searched is until after the NIT's been deployed, and then you can find out the ID and location of the target computer. And this is really troubling because what you're doing is putting the cart before the horse in that situation. And yet most courts have accepted that, other than retired Judge Smith, who's here today, who has been one of the few people to just outright reject a warrant application for a NIT warrant for saying this doesn't have enough specifics in it. But even so, even if the government isn't specifying the place to be searched, they still have to include as much particularity as they can. So they have to say, how's the NIT going to be deployed? How is it going to be installed? What were the circumstances that led the FBI to say we want to install this NIT? What else did you try that didn't work? Why do you need this? Why is this your last resort? How long are you planning to deploy this NIT for? So, for example, the Playpen warrant specified we're going to do this for 14 days. I think the government only ran it for 10 ultimately. Is that right? Or did they run the full 14? How long are you going to be running this for? What information are you going to seize? The NIT warrant in the Playpen cases did specify 7 particular items of information that the NIT was supposed to phone home to. And then how are you going to keep this from infecting other innocent users? What if there's other people that are using the computer? What if a whole family shares a particular computer and you might end up grabbing information about all of them? And so from instances where courts have expressed doubts about this particular NIT warrant or have rejected applications for NIT warrants in other contexts, we've seen that the FBI has been learning and responding, and so now we see them including language about how they're going to make sure that innocent users' privacy is not going to be affected, and assurances that the NIT's only going to be served on the target. But if that language is too conclusory, if they're not really saying, what are the measures that you're taking to make sure that this is going to be restricted, you can try and still challenge that and say, this is not specific enough. You're not saying how this is going to keep innocent users from being affected, and so that's still a particular challenge that you could raise. Overbreadth is the other thing, in addition to particularity, under the Fourth Amendment challenges that you can raise here. The search that's authorized by a warrant still has to be limited only to the places and things for which there is probable cause to search and seize them. And there are several different types of overbreadth that you can look for when you're challenging a NIT warrant. So that could be that the warrant is overbroad as to which devices are supposed to be searched. As I said, the NIT warrant in the Playpen cases said that any computer that accesses the site was the place to be searched. But if there's a site that has mixed legal and illegal content, which might be something like the Tormail situation, where it was just happened to be hosted on the same server as another site that did serve up CP, or where there's a dark web market where there's content on there that is contraband that would be illegal to buy, but it's not illegal just to look at. So you can say, look, every device that accesses this site, that's not specific enough because it's perfectly legal to be looking at some of the content on this site. You can also say that a warrant is overbroad as to how many devices are going to be searched. As I mentioned in the Playpen warrant, there was one warrant that ended up allowing the authorization, allowing the deployment of a NIT onto thousands of computers, not just here, but in other countries around the world, where, as last time I checked, the FBI does not have jurisdiction. And so that looks an awful lot like a general warrant. And when defense attorneys brought up those magic words in these cases, the courts tend to often respond kind of poorly, like, whoa, now, we're not talking about something that's that bad. It is CP, after all. We'll do whatever we need to do. But if there are going to be a lot of devices to be searched, especially in these watering hole attacks, it's unknowable before the fact how many devices are going to be affected here. And then third, you can say that this is overbroad as to how much information on the device is supposed to be searched and seized. There's not going to be PC to search and seize everything on somebody's target computer. And again, this goes back to the problem of what if this is shared with a number of different users who may be completely innocent. So if you look at the list of the information that's supposed to be seized and it's trying to hoover up a bunch of personal information, or if there is a request to do something over and above just location information, just identifying information, such as turning on the camera, turning on the microphone, other information besides just the bare minimum that's needed to identify where this computer is located and locate the person using it, you can challenge it on overbreadth there as well. So that's the Fourth Amendment challenges. I'm going to briefly talk about the changes to Federal Rule of Criminal Procedure 41, which went into effect 2 years ago, so happy birthday rule change. Again, I hope this is not too irrelevant for those of you who are mostly in state courts. Basically, this rule change went into effect 2 years ago that expressly now allows the government to conduct remote access searches. Colin's going to talk about strategies for fighting NIT warrants that were issued both before and after this rule change. So, Rule 41B restricts the territorial jurisdiction of the magistrate judges who issue warrants to within their own districts, subject to certain enumerated exemptions. Before the rule change, there were 5 exemptions. Now there's a 6 in Rule 41B6. It authorizes magistrates to issue remote access warrants for searches and seizures both inside or outside of their district in 2 particular circumstances. One is to investigate certain offenses under the Computer Fraud and Abuse Act, where a botnet is involved. That's 41B6B. I'm not going to get into that. The one that you're more likely to see, because it's not restricted to a particular type of offense, particular crime, is B6A, which says that remote access is authorized where the location of the target device has been, quote, concealed through technological means. And so that'll mean, for example, hiding a true IP address by using Tor, by connecting through a VPN, for example. We haven't seen a lot of these new warrants so far. It's been 2 years, so they must be out there, but so far the only ones that I've personally seen are some that I just saw a few days ago, actually very timely for this panel. There was an article on Vice Motherboard by Joseph Cox that came out earlier this week talking about how the FBI created a fake FedEx website in order to catch somebody by sending them a link to a landing page on this fake FedEx domain that the government itself had registered in order to catch somebody who was engaged in a business email compromise scam. I'm happy to send these to you if you would like to see them. Email me, and I will send you copies of it, or you can go to this news story and see them for yourself. I've just included like a couple of screenshots here. These may show us what emerging template might look like that the FBI and the DOJ are using now for NIT warrant applications under the revised Rule 41. But because the two warrants that are covered in this news story are both out of the Western District, New York, it might just be that the USA's office there, this is their particular template. It might not be from Main Justice, so I don't know yet. Note that neither of these involved a watering hole attack. They each involve sending a NIT to a specific particular, well, hopefully one device. So one of them was the phishing link where you're just sending a booby-trapped link to a page on a dummy FedEx site. I don't know how FedEx feels about having somebody registering their domain with their name in it. And the other one involved an infected Word attachment that purported to show a payment that had been made to the alleged fraudster in that case. Now, these aren't child pornography cases. These are business email compromise scams. I don't know if you're familiar with those. Some of you may have litigated these, where a fraudster poses as pretending to be from a vendor, for example, for a particular company that provides them services. Maybe it's, they do your accounts payable or what have you. Maybe it's a construction company, and they say, hey, we have changed our payment details. Here's the new payment information. Please send the attached invoice to this new payment information. And businesses tend to lose quite a bit of money this way. And the FBI has now taken an interest in this. It's nice to see that they're taking an interest, in helping prevent and go after fraud. But it challenges the notion that I think, Colin has said before, and I think a lot of people thought that we would only be seeing government hacking used in the most sensitive, high-touch types of cases. Now, one of these cases involved allegedly $1.2 million in losses, and the other one involved about $82,000 in losses. So I think it might be the case that the FBI might only use like super secret, high-tech investigative techniques. Then maybe they're going to reserve those for the most high-touch cases. And at the same time, though, like an infected Microsoft Word attachment is not like elite Hacksaw high-tech stuff. Like that's been around for a long time, but it still falls within the class of government hacking techniques. So we might see that happening in more run-of-the-mill cases. And maybe these super secret techniques, such as the one in the Playpen case, which the government classified as a national security, interest against disclosing it to defense counsel in order to avoid disclosing it in those cases. Maybe we'll see those being reserved for the worst of the worst cases. But I think the takeaway here is that we really need to see courts to start setting norms around the disclosure to defense counsel or even potentially to third parties such as Firefox, which made Mozilla, which made the Firefox browser on which the Tor browser is based, where the makers of a browser that's being exploited have an interest in knowing what the exploit was and what the vulnerability was so that they can patch it. Defense counsel, as Colin will talk about, have an interest in having the details of how the network disclosed to them so that they can counter it more effectively, as you heard about previously around the source code, for example, that gets protected with trade secret allegations in the AI context. So if we have courts start to set norms around saying that NITs are going to be disclosed, that will be predictability on all sides about whether the government's going to be forced to disclose that. And that might affect the government's willingness to use techniques, whether more low-tech or more high-tech, in pursuing these cases. And so to wrap up, if you have seen any of these post-rule amendment warrants in any of your cases, if that's not sealed, please send them to me. If they are sealed, please move to unseal them and then send them to me. So please give them to me. I would love to do, as part of my research at Stanford, a roundup of the last 2 years of how this has played out under this rule change. But now I'm going to turn it over to Colin to talk a bit more about how you can litigate these warrants both before and after the rule change.
All right, thank you, Riana. So what I'm here really is to give you a sense of where the technology and the legal principles meet the litigation road. Because my office ended up with several of the early Operation Pacifier cases, which involved the Playpen website. Great name for a child pornography investigation. I don't know who came up with that one, but it ultimately involved thousands of computers in 120 different countries, including Russia, China, and North Korea. So there's a whole interesting issue about the geopolitical considerations of these type of operations, which are beyond the scope of this presentation. But during this time, the FBI was the world's largest distributor of child pornography. One of the things that we targeted very early to try and set the table for the rest of litigation was discovery related to the scope of this operation, and frankly, a lowball estimate was that 1 million videos and pictures were distributed directly from an FBI server in Quantico, Virginia, as was actively operated by the agents. By the way, the user comments on the website Playpen really became quite glowing after the FBI took over, because our judge actually ultimately made findings of outrageous misconduct by the FBI in the course of the litigation, and one of those was that the FBI had needlessly improved access to the site, had needlessly improved the speed to which images could be downloaded or redistributed. It was like some grand science experiment, along with really testing the boundaries of the law. So often just getting information that may not be directly related to a Fourth Amendment claim or a probable cause claim can still be very revealing and help kind of turn the equities in the courtroom, at least in front of our judge, much more in the defendant's favor. Because let's face it, when you've got a client charged with child pornography, you're facing a lot of headwinds going into the court. And I think that's one of the reasons they're testing a lot of this technology in the child pornography context. And then moving into the white-collar criminals, to which obviously the courts might be a lot more sympathetic. Now, in the pacifier cases, the government took advantage of a defect, an exploit in Mozilla's Tor browser. The government is fond of referring to Tor as the dark web and this nefarious den of criminality, but bear in mind that the Department of Justice recommends that federal judges use Tor to protect their privacy and communication, so that's a little bit of a hard sell. And in addition, again, in terms of broad issues, one of the things is sort of the equities of using these type of malware exploits, because once they're out there, they're kind of uncontrollable. We've seen recently issues involving the WannaCry and Petya malware, and there's really was no control over the malware itself, the NIT, or Network Investigative Technique, which is just a fancy word for malware, once it was launched by the FBI into these 120 countries. So it is litigation. It's still ongoing. Cases are still being filed. My office is running a national working group on these cases, so please, we have a lot of materials, probably more materials than you can digest in your materials from this conference, but you're welcome to contact me, and I can direct you to experts, motions, pleadings, transcripts. There's a lot of resources here. But really what characterizes this entire operation is an extraordinary level of trickery, deceit, and pure illegality on the part of the government, and it took a good deal of ferreting out. And I want to just now, in the limited amount of time, really just try and flag issues and avenues of attack, some of which have proved successful, some of which are still being litigated. I have a case pending in the Ninth Circuit, which is going to take up all these probable cause challenges to the pacifier cases, so it's an ongoing process. And a lot of these cases are now actually being transferred down to state jurisdiction. We basically ran them out of the eastern and western districts of Washington, so they've moved to some state filings. You're going to be seeing these cases, and you're welcome to contact me. Part of the challenge here is just knowing that whether you have one of these cases, When we originally got our first NIT pacifier case, we got a very generic, limited set of discovery. We got a complaint which made no mention of NITS, Tor, an FBI website, nothing like that. In fact, the only flag that there was something odd going here was one sentence in which the complaint mentioned, because of the way the network, they don't even mention Tor, but they were referencing Tor, routes communications through computers, traditional IP identification techniques are not viable. All right, now, it looks like a few cases prior to ours had kind of snuck through and went directly to pleas or were settled without people even realizing that we're dealing with an NIT case. I have not dealt with these cases before, but obviously the question here is, well, if traditional techniques are not viable, what technique did you use? And that question set off a very prolonged discovery battle. And ultimately, what I'm going to be kind of flagging most importantly for you is that the discovery process in these cases not only informs the Fourth Amendment challenges and the probable cause challenges or even the outrageous misconduct challenges, because we raised that on due process grounds, but discovery itself is a sword. I mean, where we succeeded ultimately in getting dismissals on our cases was as a result of the government's resistance to our discovery demands. All right, so it's not just a means to an end, it's often the end to itself. And given the government's unwillingness to disclose most of this information, there's a lot of powerful law and even under the Classified Information Procedures Act, a lot of ammunition available to you through this process. So we developed 4 broad avenues of attack, and I think we're going to see these as recurring themes, broadly speaking. Obviously, the outrageous governmental misconduct issues, a very high standard to meet in terms of getting an outright dismissal, but it does set the table for the rest of your litigation. And our judge did, in fact, make 6 findings of outrageous conduct and illegal behavior by the FBI, which is at least powerful stuff to present to the Ninth Circuit on our way up. Obviously, the Fourth Amendment and probable cause issues that Riana has touched upon, and I'll go into a little bit more of that. Again, there are a lot of pleadings available to you in the materials that lay out these arguments with all of the case law and facts, at least related to pacifier, to show how we develop them through the discovery process and our experts. The jurisdictional issues, of course, which Riana touched upon. In some sense, these have become moot in the federal context. Partially moot because of the Rule 41 change. The judges aren't that interested anymore, but bear in mind, it's still alive and well in this sense. We now have a justice on the Supreme Court, Justice Gorsuch, who takes to heart these jurisdictional limits on governmental power and has written some powerful opinions about the core constitutional requirements surrounding jurisdiction. So, we may ultimately end up in one of these cases with a cert petition based on those jurisdictional issues, and then ultimately the discovery and due process issues that I'm going to spend probably 5 minutes or 10 minutes on compared to the other materials. All right, so just in terms of the outrageous conduct here, I indicated the scale of this, that the FBI was itself actively operating this site. And, any of you who have dealt with a child pornography case have seen and understand how the government routinely comes into court and says, just looking at these images re-victimizes the minors. All this outrage about the harms that's caused by child pornography, even when your client is just some poor schlub who's looking at these pictures on the computer. And yet they did not hesitate to become the world's largest distributor, at least during the 14-day period of these materials on the internet. And it's not just a matter of hypocrisy and morality. There are specific federal provisions addressing this behavior under the discovery rules, the Adam Walsh Act. There is actually a specific provision prohibiting the government from redistributing child pornography for any reason whatsoever. They violated that. They violated the Crime Victims' Rights Act. There are requirements of notification and consent when you're using the identity or images of a victim in the course of an investigation. All these findings were made by our judge. Unfortunately, it didn't get us a dismissal on that basis, but they're there. We're probably not going to see, I don't think, this type of thing necessarily anytime soon in regard to child pornography sites. I mean, there actually were more sophisticated ways of doing this that did not require the government to actively redistribute pornography, spoofing sites, other ways of tracking, limiting or tracking content that would have kind of at least contained the amount of child pornography that was flooding the internet from Quantico. But you know, the government's always doing something outrageous, so I'm sure new issues will turn up. So now, Playpen and the Fourth Amendment issues, of course, Riana touched upon these. You know, obviously, the core issue that we were dealing with was the particularity and general warrant issues. Playpen was not obviously a child pornography site. This is actually the homepage. It really looks like a chat room. There was no child pornography on the homepage itself. And one of the very troubling aspects of this case was that the NITs were deployed or sent to target computers as soon as people landed on the homepage. All right, so it's not as if they waited until people are logged in or actively looking at particular illicit content. All right, anybody who got to this homepage, okay, was potentially a target of having their computer searched. All right, so the probable cause analysis, when you're saying, well, you know, if somebody stumbles on a site like this, or even thinks, you know, they want something kinky but not necessarily illegal, all right, and they're going to be subjected to computer search just by visiting this homepage, that is extremely troubling, at least to me. We'll see if the Ninth Circuit cares. And then there were a number of just, at a level of detail that I kind of go into, falsehoods and Frank's issues buried in this, including a false description of this homepage. The FBI, at the time they got the search warrant, actually knew that the homepage had been changed to this kind of anodyne chat room image, but they represented in the search warrant application for the NIT that this was a very different homepage that was displaying child pornography. That was an earlier version. And again, just to show the levels to which there's you know, deception going on. When we got a copy of the homepage, it was the earlier version. It was disclosed to us, you know, under a protective order. It showed the child pornography, and we actually only found out indirectly through a search warrant photo that came in the context of another case that the site had actually changed appearance by the time they filed the warrant application. Issues regarding also hang on, let me just back up here. Disk avoidance, I'm not going to go into that, but it's something you need to file away for future reference. The way the Tor system operates is that contrary to the normal temporary downloading of images that occurs on the internet whenever you visit a website, there's actually Tor is designed to block most of that content from being automatically stored on a computer, which becomes very important in terms of establishing probable cause that images may be found on the computer, particularly if there's been any significant lapse of time between the internet activity and the search that's occurring. There were all sorts of misrepresentations buried here about the likelihood of finding images that even Playpen visitors might have viewed while on the site, actually finding those images on their computers by the time the search occurred. So a lot of technical issues that were misrepresented or not discussed at all in the warrant application. All right, so taking these just sort of quickly in turn, the jurisdiction issues have proven problematic because while a number of courts, including the Ninth Circuit, recently found that the NIT warrant was void ab initio, invalid from the get-go, they've just kind of reflectively defaulted to the good faith exception. It's particularly galling in this case because, at least in our case, it's up on the Ninth Circuit now. We've got a slightly different argument that may still get this issue before them. There's a very compelling record that the DOJ and the FBI knew exactly what they were doing. In fact, they were lobbying for changes to Rule 41 and telling the Federal Rules Committee, we can't do these type of remote NIT searches unless you change the rule because Rule 41 prohibits it under the old version, while at that very moment they were doing exactly what they were telling the Rules Committee was impossible. So those kind of things are frustrating when you're laying out the record, but again, particularly in child pornography cases, there tends to be a kind of default to deference to the government. It's all very calculated. This picture actually, Amy Hess is the director of the Operational Technical Division at the FBI, deputy director of the FBI, at least until recently. She was very forthright in the Washington Post talking about how the omissions or ambiguities or outright misstatements, in my view, in a lot of these warrant applications are calculated. She was quoted as saying that NIT warrant applications do not describe the techniques used in detail. So judges may not really understand what they are authorizing. Agents can describe the process more fully to judges, but that's only if the judge knows to ask. All right, to me, that really doesn't quite meet the duty of candor that we would hope and expect, I think, from law enforcement agents in presenting a search warrant application. Those are not my words, that's from the FBI. And you just need to bear in mind, you need to read these very closely and read between the lines, understanding the mindset that may be behind the warrant application that you're challenging. Now, in terms of discovery, we went after, obviously, a number of different things, the NIT code components. You can't really say it's a single source code. There are a number of different codes, source codes that are working together. Obviously, we went after the operation pacifier, statistics and operating records, the number of computers hacked, how the website was being operated, and the FBI site administration records. We got a lot of it. We didn't get all of it. But the only way to really push back against these things is through the sustained discovery litigation, because without the details and without the information bolstered by expert declarations, kind of explaining in bread and butter terms how these things work and how they, what they mean to the judge, you're really not going to get traction. Now, you know, you may be dealing also with a situation where the agents and prosecutors that you're dealing with are out of the loop as well. They may be making representations to you about what's available or what happened in regard to the source code or a particular computer activity, but they're kept out of the loop themselves by the operational division or other agents who really have access to the source code and know what's involved. So there are walls within the prosecutor's office and DOJ as well that you have to sometimes get around. And you have to be aware of it too, because at least in our case, we had so-called experts coming in from the Department of Justice testifying about what the NIT did or did not do to our client's computer. And it turns out they had never looked at the source codes. They didn't have access to them either. I mean, in some ways it makes it easy to discredit them, but it becomes really trying to really whack-a-mole in terms of what information they're providing that has any really basis of knowledge. All right. In terms of discovery, you know, while there is a reluctance because of classification and claims of law enforcement privilege on the part of many judges to actually turn over this information, you really need to go back and look at the law itself, the bedrock, the seminal Supreme Court cases, Rule 16 in the federal context, the discovery rules themselves, the Classified Information Procedures Act, which is in fact an extremely friendly, defendant-friendly piece of law, and remind the judges that you are not only entitled to this under the rules and as a matter of due process, but that the government is inviting dismissal by trying to withhold information from you. Jenks, of course, is a seminal case of that. And in itself says that the criminal action must be dismissed when the government, on the ground of privilege, elects not to comply with an order to produce. But again, it's a process of educating the judges. In the federal context, Rule 16, of course, is also very good. Ninth Circuit law says materiality in terms of demonstrating a need for discovery. Certainly source codes comes under this. It is a very low threshold. These are their words. All you need to know is that it may be helpful to preparing a defense or even lead the defendant to realize that a potential defense is not viable. All right, that pretty much encompasses everything that you might want in the context of these cases. And again, federal rules, Federal Rule 16 itself contains a remedy provision which says that the court may order not only discovery, but prohibit the introduction of evidence related to undisclosed material or even dismiss charges or cases. So again, those remedies are available to you through the discovery process. Great Ninth Circuit law on this point as well. It's in the materials, but the Ninth Circuit has said that it is quite incomprehensible that the prosecution should tender a witness to state the results of the computer's operations, and a computer operation is what all these cases is ultimately based upon, without having the program available for defense scrutiny and use on cross-examination if desired. I mean, this is a very strong statement of materiality for anything involving data or computer operations. So you certainly, anybody who's practicing within the Ninth Circuit, not even the federal courts, but at the state level, can find a wealth of very helpful case law, and again, it's in our materials. Now, just to wrap up quickly, because we're running short of time, and I'm happy to talk to people afterwards or take your emails. The NIT and the Operation Pacifier cases got classified because we got one case dismissed on Rule 16 grounds. All right, so their answer to that was turn around and classify the NIT. Apparently it wasn't so sensitive that they had to do anything in terms of classification prior to that dismissal, so I mean it was kind of a suspect timing. But you know, that's fine, because as I indicated to you, CIPA is actually, when you start getting into it, a defendant-friendly statute, which makes a very specific series of demands upon the court and the government in terms of doing everything possible to get the information, the classified information, into the hands of the defense. You can use protective orders, redactions. The government can require that a defense expert with national security clearance looks at the source codes or other classified data. We offered that in our case. We did everything up front with the court to show that we were prepared to meet each of the requirements of CIPA, and that the government's security concerns were baseless, or at least could be managed. And again, CIPA itself has a remedy provision which mandates that the court dismiss specified counts, find against the United States on certain factual issues that may be before the jury, or strike or preclude witness testimony that relates to information that has not been disclosed to the defense, regardless of whether it's classified. So the situation that we ultimately faced in one case was the government did not turn over source codes. The court cannot force them to do that. There's no way the court can require the disclosure, but the remedy provision for non-disclosure is what we were actually aiming at almost the entire time, very much aware that the government would most likely, despite the requirements that they should turn this information over, would not. That ultimately ended up being the climax of our litigation, because we got yet more dismissal orders under these CIPA provisions. So that's kind of a flying summary of how some of this information technically, and then in terms of what Riana presented, in terms of the constitutional principles, can actually result in wins at the trial court level. But it took us, 18 months, 2 years of litigation to figure this out. I had never done a CIPA case before. Obviously, we didn't really know what was going on with the NIT, or that an NIT was even involved at the outset. But there are lots of resources available to you. All of us are. The materials include most of the pleadings, the discovery pleadings. There's an article that outlines the Operation Pacifier litigation in my district. There are even expert declarations you can draw upon. NACTL has a handbook on government hacking, and also a webinar. So really, main thing is just spot the case. Realize what you're up against, and call us. There's an army of people here to help you, and we're on to the next battle, I guess. Thank you very much.